Last week, Judge Cahill issued his decision involving the 4 defendants accused of killing George Floyd. The court found that there's probable cause for all of the charges except one, the third-degree murder charge against Mr. Chauvin. Now, there are still other pretrial issues that need to be resolved, such as changing venue and whether or not there will be a joint trial in this case. Now, people are wondering, what is a joint trial? What does it mean to have separate trials? Let me try to explain. In Minnesota, we could look at the joint trial rule, which is Rule 17.03 of the Rule of Criminal Procedure, and you could see the standards as to whether or not a court should grant a joint trial, meaning that they take all of the defendants and give them one trial, or whether a judge should give separate trials to the defendants. Now, there's a presumption of separate trials in Minnesota, and that goes back years in case law and judicial history. In fact, we could go back to the Jerry Hoff murder. Mr. Hoff was a police officer in Minneapolis, and he was brutally gunned down back in September of 1992. 4 individuals were charged with his murder. It was a gangland-type murder. Those 4 individuals went to trial, and they went to separate trials. Each one had their own trial. They were all convicted, but they had separate trials. That's how strong the presumption is in Minnesota for separate trials. Now, the basis for that is this. When you have joint trials, whether it's 2, 3, 4, or 6 defendants, many times you arrive at antagonistic defenses, meaning that one person is saying the other person did it. It's finger pointing. And you get into situations where one defendant's evidence might be very prejudicial to another defendant's evidence. So rather than having that type of discord or that type of prejudicial evidence coming in when it should not, the courts favor separate trials. And that's basically what the court is going to have to determine in this case. Should the defendants each get their own trials?